What is up, guys? Welcome to Truth and Transparency. This is bombshellish. But first, so I have the email from AT&T that is wild. We're going to talk about that. I found a loophole in Cellebrite. I cannot believe this. And Judge Megan Marshall has her ruling, her judgment. So, welcome to Truth and Transparency. This is the Celebrite, Bombshell, and Judgment by Magistrate Marshall. And then the iOS 16 can trick Celebrite, or even like the 17. That's just like, as long as you have the iOS 16 and you're working with two iPhones back and forth, you're not going to believe this, but there is a loophole, and it's interesting. Also, I have, we've been talking AT&T, timing advance. Today just released more information on back in January, the January 6th, 2021, the pipe bomb. Well, I got the external email that the FBI released. And so I'm going to show you guys all of this, print it all off. So yeah, whew, here we go. First things first. Judge Megan Marshall. Let's see. Again, good evening, everybody. At some point during this broadcast, you're going to enjoy it or hate it. Just hit the thumbs up. Also, if you are not subscribed to the channel, that subscribe button, everybody thinks that like you're subscribing, so you're paying like a subscription fee. Like, I don't know, back in the day, the Highlights magazine, I used to love those. And we had to like pay a subscription fee for that. Yeah, no. It is free to hit the subscribe button. And all it does is it notifies you if you want to be notified when Truth and Transparency is going live. So every time I see H-Bag, I just tingle. What's up, H-Bag? Glad to see you here. All right. Check this out. So Megan Marshall here. This was the Maddie's mom, Karen. She took on the city of Moscow, and then the Chapins, they added on to it. And this is the memorandum decision granting in part plaintiff's complaint for permanent injunction. Okay. So the background, we pretty much know the background. So we're going to skip this only because it tells you about the case. I am going to highlight right here for us that as part of the investigation, videos, photographs, reports, and other evidentiary materials were generated, which ultimately led to Brian Culver's arrest. For a multitude of reasons, the criminal case garnered worldwide interest. Until July 2nd, 2025, the criminal case was pending trial. And until July 17th, 2025, a non-dissemination order was in place, which prevented the disclosure of certain records to preserve the parties' right to a fair trial. On July 23rd, 2025, a judgment of conviction and commitment was entered, concluding the criminal proceeding. So since July 23rd, 2025, the city has received over 1,100 public records, so 1,150 actually more, public records requests. Now I'm curious if they treat a public record request like when I do my request, like in one of mine, there was like 36 that made up the one. Because I did it by letters and numbers, like an outline. So I'm curious, do they consider that one? Or do they consider that 36? Just my head, All right, back at it. Over here is out of those 1,150 public records requests for information related to the criminal investigation, including but not limited, were crime scene photographs, 911 calls, police reports, body camera footage, witness statements, autopsy reports, and MPD investigatory records. In response to those requests, the city made redacted police records available to the public via a web link and disclosed 186 photographs. Guess what, guys? Let's talk about this. You know those redactions when they were like taking people's names out? Go get yourself a new one, because the names and stuff like that, yeah, you can go ahead and redact birthdays, okay? But I believe that we're going to be able to put new requests in, and we're not going to be reading this stuff as blankety blank 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 anymore. Those days are over, okay? Um, those days are over. So I started thinking about this, and I'm wondering now all the hard time I've been giving Moscow is because they were like, we know Meghan Marshall is about to release this, and why give Lana hers when she's probably going to bitch about um, the results of them? So I do have to say, I think Moscow Police Department, because we deal with legal, straight to legal, and I think they were like, we're going to wait till Meghan Marshall just drops this, and then Lana can get hers. Because all this blankety blank, I mean, I'm going to have to print a bunch of shit again, but that's cool. Um, so no more blankety blank 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 boo, and none of this like random shit being redacted. Like um, Sigma Chi, you redact a fraternity or a sorority on my public request, and I will call you so quick. You redact what somebody said, and I will call you so quick. I am done with that shit. Okay. And I also think that it's wrong. It's wrong for us to ever think that it would be somebody else. So what the fuck, you know? So bye bye. It's just not happening. So all the people that aren't going to be lazy, you'll be able to see and get the new good stuff. But so the city made redacted police reports available to the public via a web link and disclosed 186 photographs taken at the crime scene, some with blurring over the decedent's bodies. On August 11th, 2025, the city provided copies of these photographs and certain redacted video to plaintiff's counsel and informed counsel that the city would be disclosing the redacted videos, including redacted body camera videos from the MPD officers, and depict the crime scene as well as other materials within the coming days. Upon review, the photographs and the video provided, the plaintiff's counsel emailed a response to the city objecting to the release of any additional material in the case because it would constitute a violation of plaintiff's personal privacy. On August 12th, adding to Karen's filing, she also filed an ex parte motion, and it was for temporary restraining order, just like immediately until we can talk about it. So they went ahead and did that. Then they had following an in-camera review of 4 redacted body cam videos and approximately 181 photographs. So I believe that this is still outstanding. Right here. I don't believe that anybody has this. And so I think that that's going to be released. Again, this is just my guess. Based off of what I've seen. Okay, so here we go. August of 2025, the temporary restraining the city from disclosing any images. Now look at this. So there was going to be no disclosing of any images, audio, or video depicting the inside of Maddie's bedroom until a hearing on the preliminary or permanent injunction. So on August 21st, 2025, the city released additional body cam video and crime scene photos that blacked out the bedrooms entirely in lieu of blurring the decedent's bodies. On August 23rd, 2025, plaintiffs filed their first amended complaint because they added the Chapins, as well as they were seeking permanent injunction restraining the city from releasing the following. There's 8 things, and this is really important because this is, the only thing I can think of is this. Maybe they looked at it as like, here, we can go ahead and issue this out to people, and they're going to pay for it twice. Okay. Because let me see how I want to explain this. So if I did a public records request, right? And you go ahead and you've already given me, let's say, a video that one that we've seen, right? Just pick whatever one. Pick Gunderson's. Okay. Um, do you think that I should have to pay for another copy of that? Because obviously it's going to be different, right? Meaning you're going to go back to the original and there's going to be no more blurring of just straight black rooms. Also, all of this like redacted what people are talking about. Like, do you think that I should have to pay for that? So I'm just curious your guys' thoughts to kind of explain that. But because basically we got like, I don't want to say it. It's like you got Skinamax, right? And instead of like, I don't know. So I'm curious on how they're going to do that. If they would make somebody like pay, because if they're just doing it based on the redactions, there should be hardly any redactions. Because you can't redact certain things, right? They were redacting all this excess of shit, and so here, we're being quoted for all of this redactions that aren't going to be taking place. So are you going to have to give me like a new quote then? Because the only thing that should be redacted is black. What they're saying is black boxes over the bodies. That's it. So, okay, so let's go back here. Now, number one, they were asking that images of the interior of victims' residence. Well, that didn't happen. Number two, images of the victims, whether blurred or not. This was in part because they're just doing black boxes over bodies. And if there's immediately like basically if they were like in like a pool of blood, they're going to try to say whatever. If there was blood like immediately around the body, they're going to try to do that. I think that's absolutely wild. And if anybody challenges that, I mean, I think I could appeal that and win it. And I'm not a lawyer. So, okay. 3, images of the bedrooms where the victims were murdered. That did not win. So we're going to be able to see the bedrooms of all the bedrooms. Every room. Number 4, images of the death scenes, murder scenes, including images of pools of blood, blood spatters, and dried blood. Like I said, it has to be immediately next, like immediately around the body. You're going to see, I think this is going to get out of control. I think that this it's like you just put a rectangle, you know what I mean? And then that's just it. I know that on some stuff that I've seen, they would put like black boxes over like eyes, and I don't know. Can they put a spotlight on the sheath? They want to put all these black boxes. We just want to see the sheath, you know. We want to see if you could see it from the door. We want to see if you can see it here, right? Number 5 is this didn't win. This didn't win. Number 5 is images of the personal property and items of the victims of the homicides found inside the interior and exterior of the residence, including but not limited to containers of alcohol. First of all, we don't even know whose alcohol those containers are. Underwear, ID cards, and other personal items. This lost. We're going to be able to see all of that. Number 6, images of witnesses, including witnesses hugging each other and sobbing. That lost. Okay, so we're going to be able to see that. So remember those blurred images where I'm just like, you guys are showing camel toe girl like full blown, and yet there's just a big old blur, okay, of all the people huddled up in the street. That's not going to happen anymore. Yeah. Next. Number 7 is video and audio media containing sounds of the witnesses, including sounds of them sobbing. That lost. And then number 8, video and audio media containing statements of witnesses given to law enforcement officials, including statements evidencing their extreme emotions. That lost. Okay. So on August 25th, 2025, the parties submitted a stipulation of the parties submitting the matter for a decision on the permanent injunction based on the declarations, pleadings, and briefings on the file. Then on August 28th, that was when the hearing was held. It was over Zoom. And then they go over like the legal standard. And so this all falls under Rule 65 of the Idaho Rules of Civil Procedure. A party may petition the court for an injunction and or a restraining order in a civil proceeding. While Rule 65 addresses temporary restraining orders and preliminary injunctions, it only briefly addresses permanent injunctions by stating that, quote unquote, before or after beginning the hearing on a motion for a preliminary injunction, the court may advance the trial on the merits and consolidate it with the hearing. Here, the parties stipulated to essentially forego a hearing on a preliminary injunction and instead submit the matter for a decision on the permanent injunction at the August 28, 2025 hearing. Unlike a temporary injunction, a permanent injunction is entered at the resolution of the case and requires a showing of threatened or actual irreparable injury. And so it cites that case. Further, in order to deny a permanent injunction, the trial court must be persuaded that there is no reasonable expectation that the wrong will be repeated. Okay, so the IPRA provides a statutory mechanism by which members of the public may review public records so that they may be knowledgeable of the operations of their government, the performance of the public officials, and the formation of the public policy. A public record is defined as any writing containing information related to the conduct or administration of the public's business prepared, owned, used, or retained by any state agency, independent public body, corporate or political or local agency, regardless of physical form or characteristics. Every person has a right to examine and take a copy of such public records. But the motivation of the person requesting the public record is irrelevant. So remember, that was an argument of theirs, is that these people are going to go out and, put this stuff all over like their YouTube channels, whatever, blah, blah, blah. That's irrelevant. The motive of what I want with my public request doesn't matter. Does not matter. It's irrelevant. So we all knew that, but so the public's right, and consequently any individual person's right to inspect a public record, is conditioned solely on whether the document is a public record that is not expressly exempt by statute. So it's just, is it or is it not? Specific to this case, law enforcement investigatory records are public records. Investigatory record means information with respect to an identifiable person, group of persons, or entities compiled by a public agency pursuant to statutory authority in the course of investigating a specific act, omission, failure to act, or other conduct over which the public agency has regulatory authority or law enforcement authority. Generally, investigatory records are defined So this is the code IC 74-1016, are subject to disclosure under the Idaho Public Records Act. When a request to examine is made, the public agency or custodian has a specific time in which to review the record and grant or deny the request. There are certain exceptions to disclosure as enumerated in 74-124, 1A through G, that justify a public agency denying a request. One exception is where production of records would constitute an unwarranted invasion of personal privacy. An unwanted invasion of personal privacy is defined and disclosed as follows, and that is Roman number 1 and 2. Disclosure of information used to identify, locate, or harass a juvenile, a victim of an alleged crime of mass violence or domestic violence, or a victim of physical or sexual abuse. Megan said that doesn't apply. And she said that there were some stuff that applied here. Disclosure where release of information is likely to violate legitimate and substantial privacy interests of the person identified when such interests are weighed against general public information. You know, I'm like, they're dead. This is like, I don't know. I have no idea how they're doing this. And I actually don't think that it's legal. Okay. And I'm going to explain what I mean right here, but none of these apply. Okay. You cannot claim a privacy interest for somebody else. It says it right here. It says personal. It says the word personal. Again, disclosure where release of information is likely to violate legitimate and substantial privacy interests of the person identified when such interests are weighed against general public. And so because they're actually basically saying, I think I kind of said it a little wrong. Hold on. How I want to say this is it doesn't use the word personal. So I'm allowed to say that the person that you're identifying, they would have they would violate legitimate and substantial privacy interests of the person identified when such interests are weighed against general public information. So the parties agreed that the records to be disclosed in this matter are public records, and more specifically, law enforcement investigatory records. The inquiry for the court is whether the specific records are exempt from disclosure under C, which is the city would be restrained from releasing them to the public or any specific requester. Plaintiffs argue disclosure of the public records, specifically photographs, audio, and the plaintiffs, remember, that's, Maddie's mom and the Chapins. That they're saying that specifically the photographs, the audio, and the video created by law enforcement at the crime scene or decedent's residence would constitute an unwarranted invasion of personal privacy, and therefore the city's disclosure would violate. On the contrary, the city argues the records are not exempt from disclosure because plaintiffs do not have standing or authority to assert a privacy interest either on behalf of themselves or on behalf of the decedents. And if plaintiffs can establish a privacy interest, that interest is not outweighed by the public's interest in disclosure. So then the city was even just like, well, let's say that you guys could even find a way to do that. You're still not going to outweigh the public's interest. Okay. Now, let's see. Okay. Number one, plaintiffs have standing to assert a privacy interest in the records to be disclosed. First, the court must determine what privacy interest, if any, plaintiffs have in law enforcement records they seek to keep from public disclosure. To determine this, the court must look to the language of the statute and the cases which interpret what statutes as an unwarranted invasion of personal privacy. I've never actually seen like somebody breaking it down like this. Let's talk about, okay, let's go to the language. To begin, IPRA defines an unwarranted invasion of personal privacy as either one, a disclosure of information used to identify, locate, or harass a victim of an alleged crime of mass violence, or disclosure where release of information is likely to violate legitimate and substantial privacy interests of the person identified when such interests are weighed against general public information. Plaintiffs argue the plain language of the statute confers standing for them to bring this action because the information being disclosed depicts the victims' bodies, which identifies the victims, and may be used to harass the family members who are considered victims as set forth in IC 19-5306. The Victims' Rights Statute specifically defines victim as an individual who suffers direct or threatened physical, financial, or emotional harm as a result of the commission of a crime. Further, plaintiff argues that the language, privacy interest of the person identified, is the person who identifies as having their privacy interests violated. Contrary, the city argues that because of the privacy interest of the family members is not specifically mentioned in the statute, the legislator did not intend for such to exist. So, like, you're trying to like make the words mean what they don't. Okay? Like, we all know what this means. But here, this is just, I think that they're trying to twist it what it means, you know? You know, I said it the other day, too. I said that I was like, wow, if we're going to go off of what Judge Hippler said, wherever you go and you discard your DNA, you have no privacy interest in that. And that would be also a crime scene. So, but, okay, so we're right. Okay. Moreover, the legislature specifically defined the privacy interests of quote unquote any deceased person. 74-10117B. When disclosure of certain information is permitted after notification to next of kin, but opted not to include the same definition in 17A. The city acknowledges in drafting this provision that the legislator recognized privacy interests do not evaporate on death, yet argues because it did not include the same language in 17A, such provision does not grant plaintiffs standing to assert a privacy interest on behalf of the decedents, unless a probate is opened and they are serving in a personal representative capacity. Interestingly, but see now, okay, now this is where it does get interesting. Okay. Megan Marshall says, interestingly, in arguing that the plaintiffs have no privacy interest to establish standing, the city, in quotes, believes that it struck the appropriate balance in quote unquote balancing the plaintiff's privacy and the interest in an informed citizen. So basically what she's saying here is that the city's actions to blur certain portions of the investigatory records prior to disclosure and balancing plaintiffs and the public's interest cut against its standing argument. And I'm like, well, that's not our fault that this guy's a fucking idiot of what they did and how they argued. Do you get what I'm saying? Like, they're like, well, if you didn't believe that they had any privacy interest, then why weren't you just ripping it out the way that, you know, however, from jump? Okay, well, just because they didn't doesn't mean that, oh, well, you're shit out of luck. You get what I'm saying? Like, what? It's just like, wait, because they aka Moscow Police Department, was like, we're going to just do whatever we want, that down the road that would somehow affect, like, yeah, it's not our fault they were being dumbasses. That's what I was like, wait a second. I'm like, this truly cannot stand. Like, right? I'm like, this doesn't make any sense if she's really going to try to make this argument. Like, really? Like, this is what you. So, again, she's saying that the city's actions in blurring certain portions of the investigatory records prior to disclosure, right, and balancing the plaintiff's and the public's interests cut against its standing argument. While knowing that the presumption under IPRA is full disclosure, right? When asked why it took the affirmative, if it's full disclosure, then why are you even blurring? What are you doing? Why did it take affirmative action to blur or redact the initial disclosures prior to any court intervention? And the city responded that it did so in reliance upon the exemption under IC 74-1241C. And it's like, okay, just because they did it doesn't mean it's right. Just because they're claiming that, Thus, basically, she's saying that because you guys said that, you're basically agreeing with the plaintiffs. Okay? You're basically agreeing with the plaintiffs that they actually have standing under this 17-1241C. But again, it's going to go back to this, though. It's not my fault or yours as a citizen, right, that Moscow Police Department did that. We don't get fucked because of their fuckerage, because they're dumb, because they did whatever they did. You understand that? Like, this is wild. And what I mean by wild is, I think when I told you that I could beat this, okay, you could beat this. This would never fly. This is never. If somebody wanted to challenge this stuff that's written in here, I don't think they're going to have a hard time at all. Look at this. This is me. So dumb. Thus, agreeing that if plaintiffs have no privacy interest to assert on their own behalf or on the behalf of the descendants, it would have been unnecessary to blur or redact the records. Instead, under its statutory obligations, it was required by the law to disclose investigatory records on request with such redactions. And it's like, well, just because that's what they did and this is what they said, this is so dumb because they're idiots. That's their argument, and it's wrong. They should have never done it in the first place. But why would, just because they did it incorrectly, would you keep doing it incorrectly? While plaintiffs are considered victims and afforded certain rights as set forth in 19-53065A, the court finds that 74-10117AI does not have application in this particular case. The information to be disclosed is not being used to identify, locate, or harass a victim of an alleged crime of mass violence. There is no alleged suspect or unproven crime. The victims are known, they're located, and the murderer has been convicted and sentenced to life imprisonment. Likewise, disclosure is not being used to harass the victim, even if the term victim encompasses family members. However, she says, though, she does believe that I, Captain. She believes that I. And remember, when you go back to here, that's why I'm saying I up here. So let's see how she correlates that, right? And she's saying that I. The Idaho Supreme Court has yet to address the issue of whose privacy interest is protected under 74-1241C or 17A. But cases from the U.S. Supreme Court that have interpreted a similar provision under the Federal Freedom of Information Act provide guidance. This is why I think that this is going. If you wanted to rock this, you'd be able to rock it all day. Under FOIA, a public agency shall make records available except records or information compiled for law enforcement purposes that could reasonably be expected to constitute an unwarranted invasion of personal privacy. However, unlike IPRA, there is no definition of unwarranted invasion of personal privacy within FOIA's statutory scheme. Instead, leaving the issue of whose privacy interest may be asserted or protected to federal courts to interpret. Well, we're not in federal court. Of interest. So the U.S. Supreme Court held that FOIA recognizes surviving family members' right to personal privacy with respect to their close relatives' death scene images. In that case, the decedent's family members sought to be shielded by the exemption to secure their own refuge from a sensation-seeking culture for their own peace of mind and tranquility, not for the sake of the decedent's reputation or an interest personal to the decedent. Even so, the court held that we think it proper to conclude from Congress' use of term personal privacy that it intended to permit family members to assert their own privacy rights against public intrusions long deemed impermissible under the common law and in our cultural traditions. This does not mean that the family is in the same position as the individual who is the subject of the disclosure. We have little difficulty, however, in finding in our case law and traditions that the right of the family members to direct and control the disposition of the body of the decedent and to limit attempts to exploit pictures of the deceased family members remains for public purposes. Family members have a personal stake in honoring and mourning their dead and objecting to unwarranted public exploitation that may, intruding upon their own grief, tends to degrade the rights and respects they seek to accord to the deceased person who was once their own. This well-established culture tradition acknowledging a family's control over the body and death image of the deceased has long been recognized at common law. Further, while not controlling, a district court in Ada County also concluded that, quote-unquote, family members of deceased persons have a right to avoid public disclosure of their deceased family member's corpse and other death scene images that would impugn the character of the deceased or of the family's memory of the deceased. And this just happened, this decision was in March of 2025. Here, plaintiffs seek relief for both their own privacy and on behalf of the decedents. Whether the privacy interest of the person identified is the decedent or the family member of the decedent, plaintiffs have established a recognized privacy interest in preventing disclosure of images or videos depicting their deceased family members and the death scene that would impugn the character of the decedent or their memory of them. Therefore, plaintiffs have standing under 74-124(1)(c) to bring this claim. Plaintiffs have proven their privacy interest in preventing disclosure of certain investigatory records without additional redactions outweighs the public's interest in disclosure. Having established plaintiffs have standing to bring this claim, the next inquiry is whether their interests outweigh the public's interest in disclosure. Our ruling that the personal privacy protected by Exemption 7C extends to family members who object to the disclosure of graphic details surrounding their relative's death does not end the case. Although this privacy interest is within the terms of the exemption, the statute directs non-disclosure only where the information, quote-unquote, could reasonably be expected to constitute an unwarranted invasion, end quote, of the family's personal privacy. The term unwarranted requires us to balance the family's privacy interest against the public interest in disclosure. Therefore, the weighty privacy interests the family members have death scene images of close relatives must be weighed against the public interest in disclosure to determine if disclosure would result in an unwarranted invasion of privacy. There can be no doubt that the photographs, video, audio, and other investigatory records in this case are incredibly disturbing. The records are difficult to digest and provide a raw view into the horrific tragedy that occurred on November 13th, 2022, that impacted plaintiffs, a college community, and the world at large. Prior to releasing these records, the city took measures to blur the decedents' bodies to prevent an unwarranted invasion of personal privacy while balancing the public's interests. Do you see how that act right there? Like, prior to releasing these records, the city took measures to blur the decedents' bodies to prevent an unwarranted invasion of personal privacy while balancing the public's interest to comply with its statutory obligation. That's why they said they did it, to comply. Plaintiffs have a recognized privacy interest, but on balance, the public has an interest in the investigatory records concerning this horrific tragedy and how the investigation was conducted. Regarding each set of investigatory records identified by plaintiffs, in their complaint, their interest must be weighed against the public's to determine whether release would constitute an unwarranted invasion of personal privacy, not just a warranted one. It has to be unwarranted. Plaintiff's privacy interest in preventing disclosure of the death scene images that would impugn the character of the decedent or plaintiff's memory of them or continue to re-traumatize them, causing extreme emotional distress, outweighs the public's interest in how the investigation was conducted or the scrutiny upon government action. Again, this can be appealed if you think. You can appeal that. Next is they're saying that even the city's action in performing certain redactions supports this conclusion. We don't care what the city did. Just because the city did it doesn't mean it's right, doesn't mean it was lawful, doesn't mean anything. There is little to be gained by the public in seeing the decedent's bodies, the blood-soaked sheets, blood spatter, or other death scene depictions. Whereas the dissemination of these images across the internet and in public spheres where plaintiffs may come upon them happenstance, as has already occurred, causing them extreme emotional distress in an unwarranted invasion of personal privacy. The city has blurred certain portions of the investigatory records, but additional redactions are necessary to ensure there is no unwarranted invasion. The blurring is simply insufficient, as it still allows the viewer to see the outline and contours of the decedent's bodies and invites rather than dispels any speculation about how, where, or why they were positioned. Can you believe this? Let me just tell you something. Ann Taylor, in their arguments by the defense team, that if Ann Taylor doesn't talk like she did and doesn't put in her motions the way that she did and didn't go out and get experts to file expert opinions based on the death scene, that it was multiple perpetrators and multiple weapons, I could agree with you, Judge Magistrate Marshall, but because of those disclosures and because of these opinions, no, I disagree. You get what I'm saying? Like, it's those experts weren't lying. when they issued their reports off of the evidence. So that's just my thought on that. Going back to the sheet here. The fact remains, the murder investigation and the criminal case are closed. Releasing these records will have minor effect upon those who continue to be perplexed by the facts or fixated on unfounded conspiracies, whereas it has and will continue to have profound effect upon the decedent's loved ones. The city may disclose the investigatory records in this matter, but must black out any areas within the images, photographs, video, or other media that depict any portion of the decedents or their bodies and the blood immediately surrounding them. So this is immediately. What's immediately? Immediately surrounding them. Like that's. I think that's vague. I don't even know what to say about that. Immediately. I don't know. What's immediately? Just so we're clear, everything in a bedroom would be immediately surrounding me when the bedroom is like, I don't know, 5 by 10. Immediately. And it means close to or touching. I think the body should be redacted, and that's it. Let me ask you this. So if we were to get the crime scene photos of, let's say, Maddie's room, and there was just a big black box over the entire what? Bed? Like, do you think that the boxes should just have to be like, here, this is this person, and there's just a box over that? I mean, and then there's another person over here, so I have to put a box around them, or am I just making a big box to cover it all? Lana, is your name in another legal document? I have no idea. What the fuck are you talking about? Why are you asking me this? We were talking about this filing. I think just use a blur, not a box. I just, that's what I always thought it was. Honestly, I thought they were going to come back and talk about that. I think this is just horribly written. Sorry. Yeah, it's going to definitely be box or blurred. Well, no, they said that nothing's going to be blurred anymore. It's just going to be like, I just think that they're going to get a lot of pushback, and I think that guy knows that. And they also said that regardless of which way they went, they believe that this was going to be appealed. So we'll see. And, Moscow actually has an interest now, a financial one. Okay. Because 1,150 requests, huh? And how much are you charging people per request? I don't know. I just think the wording's immediately. I've never heard of a crime scene where someone's like, we have to cover up that blood over there. I'm just saying, like, it. Trust me, as a family member, I'd be like, yeah, I don't want any, but reading this is just bizarre. So let's go back to here. So immediately surrounding them. Contrarily, the court cannot find plaintiff's privacy interest outweighs the public's interest concerning the dissemination of audio, video, or photographs depicting. So this means that you're not going to be able to just go in the videos of like the all the body worn camera. It's not going to just be able to have a big box, just so we're clear. It's not going to be like that anymore. It's yeah, it's not going to be like that. And in fact, it breaks it down. It says that number one, the interior of the bedrooms, except as provided above. So there's going to be, first of all, no more this audio, like everything that the guys are saying that they say when they're there, whatever they're discussing, there's no more redactions. So all of the dead air that we're getting, that goes bye-bye. The exterior or interior, including rooms other than the bedrooms of the residents, same thing. So there's no redactions in those rooms. Okay. Like Dylan's bedroom, all of it. Every body cam that went in there, every photograph that's taken in Dylan's room, every photograph that's taken in Bethany's room, or Bethany's room, every video, and then every video in Kaylee's room, every picture in Kaylee's room, and then all the videos and all the pictures of any room. And they're only supposed to be black. There's no more of this big black, and it's just the whole room. It's just got to be where the bodies and then immediate blood. I'm just like, someone says, who cares? Nothing happened in those rooms. Actually, a lot actually happened in those rooms. You'd be surprised. Let me throw you an example. I know I personally want to see what Bethany's bed looked like when they took pictures when they were out of the house, and Snyder goes in there and he's taking pictures. I want to see what Bethany's bed looked like, because 2 people slept in that bed. I want to see what the room down in the first level to the right side where this green jacket is. I want to see, obviously, Dylan's room in terms of how her I want to see the blinds. I want to see if she could see anything. I want to see the different angles that they would have taken when standing in Dylan's room. Because you guys know now all these pictures are going to come out they take like 13,000 pictures. The different angles from Dylan's room. I want to see if Kaylee's room, if her bed sheets were down at all. I want to see if Murphy's dog food bowl, water bowl, kennel. I want to see where all that stuff is. I want to see where Murphy's dog food is. In Kaylee's room, I want to see if anything was packed in Kaylee's room. I want to see an all black outfit that Xana was wearing before she changed into a hoodie and underwear. I want to see where there's any towels in the house. If anybody took showers, where the towels were. I know I was really notorious for leaving my towels all over the place when I was in college. Not really good about hanging them back up, but they would be laying over my bed or something like that. Yeah, I think that those other rooms tell you a lot about what else did they take in? I was just like, why are these silly redactions of like whatever's on the floor is no longer redacted because you think it's whatever. Like there's none of this bullshit. And there's no more of this, oh, we're going to redact what Jack D said, or we're going to redact what one of the officers said when they're standing outside or walking to the house, or we're going to redact what from these written works. I was going over here and I was reading something yesterday again, and I was like, who damn dear, like, why is there a whole big section of Dylan's part of her interview with Blaker, and there's like 3 lines redacted? What the fuck is that about? What could she possibly be saying that needed to be redacted? And anybody describing the scene, that's not getting redacted anymore. The written work and whatever is in there, no more redactions. So, the personal property and items of the decedents found in the interior and exterior of the residence, including but not limited to containers of alcohol, underwear, ID cards, and other personal items, nothing's being redacted. They're saying this is all fair game. All the audio, all the video. 4, witnesses, including audio of crying. All of that, not fair game. 5, statements, keyword here, statements of witnesses given to law enforcement officials, including statements evidencing their extreme emotions. Those are fair game. Well, do we have to ask them that, how are you redacting the word Sigma Chi? Sorry. Tom says, what about a dumpster? Yeah, no more redactions of that. And so if you want to be able to call out the people that do the, your FOIA request, when you send it back and say, see judge or see magistrate marshals, here it is. Those officers have no privacy interests in what the fuck they said. Okay? And it's enough of redacting them talking to each other. It's ridiculous. Right? It's bad. Blankety, take your, they're going to have to release those 314 reports again, because who wrote them. Before I came on here, immediately wrote, and I said, when can we expect the 314 reports on that website that you guys did specifically for this? When can we expect those to be unredacted? Like, none of that stuff needs to be. It's birthdays. That's it. Then I think I even sent them. Yeah, I attached my first video that I got. I said, look at these videos that you sent out when I was getting like the body cam for like when it was a noise complaint. They didn't blur out the ride along. They didn't blur out a single person. They didn't blur out, the sign guy. I mean, you name it. Nothing was blurred out. Nothing was redacted in terms of like whatever they said, they said. There's none of this, oh God, that makes them look better. Oh, there is none of that. That's not why you can redact things. We have an interest in seeing how they police over there. Right? The internet sleuths fucked up their plans. I mean, it's insane. Like, I was watching some the body cams over here in Columbus, Ohio. The ones I like to watch are like the drunk ones after football games. These people crack me up. they're not getting their shit redacted. They look like idiots, right? Like just complete fucking drunk idiots. And it cracks me up. Like, can you imagine if you think I'm gonna watch that if none of that if it was all redacted? I wouldn't hear any of their stupid ass like comments. Like I don't know where I'm at, man. I just want to go ride my dog. Like what? Like that's what people like. They're just so drunk and they're just saying the stupidest shit. I think that's just funny. I'm like, but people are putting them out for that reason. Where I'm like going in body cams because I want to see the investigation. So, all right. So yeah, it's all here. That it says that under the law and facts presented, the court cannot find that plaintiff's privacy interest outweighs the public's interest regarding these items, such that their release would constitute an unwarranted invasion of personal privacy. Plaintiffs and others unnamed in this lawsuit. So, like, these records, much like many law enforcement investigatory records, invade the privacy province of individuals, including suspects, witnesses, victims, and the like. And here, plaintiffs and others unnamed in this lawsuit. However, so it says, however, this is their argument. And it was just like, yeah, no, you're not doing this. This isn't happening anymore. And so this just isn't about, so everything that they've already put out, you guys are going to have to put out all new shit. I'm demanding it. I'm not fucking reading blankety blank blank blank. Like, what the fuck? I don't even know what that says. Despite the horrendous nature of this tragic event and its distressing dissemination across the world, the fact remains that it was a quadruple homicide with investigatory records. These records, much like many law enforcement investigatory records, invade the privacy province of individuals, including suspects, witnesses, victims, and the like. And here, plaintiffs and others unnamed in this lawsuit. However, these records are precisely what the law affords the public to obtain under IPRA. Under the law and facts presented, the court cannot find that the plaintiff's privacy interest outweighs the public's interest regarding these items, such that their release would constitute an unwarranted invasion of personal privacy. Boom. This right here is how and why I was able to write my letter. And I said, when can I expect the 314 different reports, all of it unredacted? Just like this, just like she says. When can I expect all of the pictures and take the ones that you've already put out? Because, like, if there's any redactions on there that's not this, it's all going to be all new. The one good thing in the ruling is that we're going to get all of the reading stuff. So picture of sheath and evidence going to be released. I think that there's going to be some of those actually that will come out, because if they did what they said they did, you know what? Maybe I can put in for a request that says that there's got to be an angle that, because that's a piece of evidence. They're going to have to figure that out. But I think this is, this is what's crazy. So if I'm like Bethany, Dylan, Emily, Hunter, you name it, all these witnesses, right? They're like, gosh, if Maddie's mom would have probably never went and did this all would have never happened, right? And it would have taken somebody to really push back on like these reports and these redactions and these reports, right? Well, here we don't got to push back on shit. This is now a judgment. So, send this in to Moscow Police Department and say, I would like you to re-release your 314 reports, and It's saying that here it is. All those people's names, all those blankety blank blank blank, gone. Everything's gone. It's all your names are going to be known. Sorry. I was actually cool with just using first names. I was like going to write in about that, but because then you can do your own. Come on. Yeah, this prevents more lawsuits for those reports. Yeah, right, exactly. Lana, I'm making the rules stop you from requesting it. No, these rules actually like this all helps. This all helps my work. I think that's why they actually were hanging on to my big daddy for you. I wouldn't have accepted that shit. Let's see. Okay, so release of certain images, video, and audio have caused plaintiffs to suffer irreparable injury, and there is a reasonable expectation that continued release will cause further irreparable injury, such that a permanent injunction is warranted. So, also further releasing images that include alcohol containers, underwear, ID cards, or other personal items of the decedents may appear embarrassing or reveal speculation as to what may or may not have occurred within the residence, but it does not. It does not. Sorry, but it does not impugn the character of the decedents in any way that constitutes an unwarranted invasion of personal privacy. Therefore, the city shall, upon request and in accordance with its statutory obligations, disclose the investigatory records, except as to the death scene records noted above, or those subject to any other statutory exemption or redaction rule. People that think this is a bad ruling, it really, honestly, this is giving us everything else. Take everything else, and we'll see what they try to do with their little boxes, and then we'll go from there. I want to know about the whole, could this have been multiple perpetrators, and could this have been multiple weapons? I don't know how we're going to be able to figure that part out, though, the multiple weapons, but I want you guys to take a look at something. Let's go with this. Okay, so going on to the bombshells for tonight with the AT&T and the Celebrite. Okay, how many people out there have iPhones? Well, it doesn't matter if you do or you don't. What matters is that Bethany and Maddie had iPhones, and it matters that did Molly McMichael have an iPhone, and did any of these other, CI informants have iPhones? Reason being, I had an epiphany. And it was because I was editing one of my text messages, and I said, oh my God. I said, if I edit one of my text messages, right? First of all, when was editing a text message or an iMessage from iPhone to iPhone? When were you even able to do that? Like, was it even available in 2022? So I looked that up and I was like, okay, it is. It's available. It was available to do in 2022. It was available to do if you had iOS 16 or better. And so if you had an iPhone and you were iPhone to iPhone, you could do this. You could click on, so I'm going to show you a video where this guy just shows you what it looks like and how to do it. But what's interesting is there's a loophole with Cellebrite. Okay, hold on. I'm talking about Cellebrite. This is really important about Cellebrite. It's talking about the download. And in the download, it does not tell you that it was, okay.
Starting in iOS 16, you can edit or unsend an iMessage after it's been sent. In an iMessage conversation, to edit, touch and hold a message until the menu appears, and tap Edit. You can tap the Close button, which looks like an X, to the left of the message at any time to cancel editing and return to your conversation. You can make edits or even rewrite the entire message.
Boom.
Just tap the check.
Okay. Boom. Did you guys just hear what they said? You can either edit or you can rewrite the entire message. Okay. So you could actually just go and write down XY, 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 XY and keep going back and forth, and just so that you have these bubbles available so that you can then go back in them. Okay. I'm just saying. And you could actually make them say whatever the fuck you want, because you have 15 minutes to do it and you have 5 edits per message. But what's crazy is that when you actually put your phone and it's downloaded through Cellebrite, when it's downloading it through Cellebrite, it will not detect that it edited your message 5 fucking times. And this is the final version. Let me show you what I mean by that.
Mark to the right of the message when you're done. You have 15 minutes to edit from the time you send the original message, and you can edit the same message up to 5 times. You and the recipient can view the edit history if you are both using iOS 16. Just tap Edited below the message to show what changes were made. Tap Hide Edits to return to the conversation. Need to unsend an iMessage? You can make a message disappear within 2 minutes of sending it. As long as the recipient is also using iOS 16, the message will disappear for them too. Just touch and hold a message until the menu appears, and tap Undo Send. That's it. Edit, unsend.
Okay, so this is what's crazy about it. I was practicing with this with one of my mods. I was like, let me show you what I mean by it. You could take a screenshot, just saying. I can do a screenshot of what our messages would look like, right? Screenshot it. Then I could go back, because if we were typing back and forth so quick or whatever, and then I can go back and just start writing in whatever the fuck I wanted. I could go back and write in that the message that I sent you that says, "Oh my God, there's fucking blood everywhere." I go back and say, "Get down here, run down here now." I'm just saying. More importantly, you could delete messages, right? You have 2 minutes to delete an iMessage, right? But then you can also go into your bubble text thing, and that's what they were talking about. And you could like actually physically delete a message that you wouldn't be able to see, like if you were just to like take a screenshot of your messages. But then I was like, okay, I wanted to ask Cellebrite if I was to edit, and what it originally would have said, would it come up in Knowledge C as an artifact of what I did? And it said no. It said, in quotes, if I was to, let me go back to I was like, hot damn. I said, no way. Way. Let me get to my pictures. Okay. Yes, you could edit iPhone messages in 2022 with the instruction of the iOS 16. This feature allows you to edit an iMessage for up to 15 minutes after sending, but only if the recipient is also using iOS 16 or like newer model. Okay. For older operating systems, the edit is seen as follows above, but that's not what I was looking at now. I want to read the Cellebrite because I only cared about Cellebrite. I only cared if you could, if you switched anything by editing, what did Cellebrite think about it? Like, would it register? CNN even did an article about it. Fuck CNN. Okay. Celebrite cannot determine. So if we were to like get your phone downloaded, there would not Celebrite could not determine any of the edits previous until whenever your phone's plugged in, it's downloaded, whatever is up there is up there. It does not have any of your edited messages in the knowledge sea. And I said, that's just fucking wild. I was like, I wonder if Celebrite truly knows that. Because that's pretty fucked up. You guys, police would know this. CIs would know this because they work with police. It's a loophole right now until Celebrite fixes it. I think that's a problem. They need to fix that. So it's not in the cloud. No, it doesn't register. That's what it's saying. But how about this? Let's just ask the Barnharts. Anyways, now, next up. So, if you really think that this was a conspiracy and ways that you could make some stuff, happen, I've always been so. I told you guys those text messages have never sat right with me, ever sat right with me. So, okay. Here we go. Now, this was just released today. Talk about perfect timing. I'm going to make it bigger for you. Okay, this is external email RE request for assistance regarding the FBI pipe bomb investigation and data provided by AT&T. Tuesday, March 18th, 2025. Now, remember, this happened in 2021. So, from legal, WF FBI, Tuesday, good morning. Again, my apologies for the delay. Please see the below statement. When the AT&T public sector team received notice that the January 11th preservation request was forthcoming, it was late in the night. Knowing that this data would likely be purged at midnight Eastern time. So right, I want everyone to see that right there. AT&T works on Eastern Standard Time. Remember I told you guys that when a search warrant would be written up, and depending on what time it's written up on the West Coast, let's say that you write a search warrant up at 7 p.m. West Coast. Just so you know that it's 11. It's 10 rather. It's 10 on the East Coast. If you try to write a search warrant at, I don't know, 10 p.m., 11. I'm just, and you're sending it through like a portal or something like that. Well, everything that AT&T does is in Eastern Standard Time. So before I actually read the rest of this, I'm going to read you part of this article. It should be fine. Okay. So, the public sector employee attempted to preserve more precise location data, which was available to them. We refer this data set as timing advanced data, which is TA, which provides the distance between the mobile devices and the cell tower it is interacting with. At that time, our public sector employee understood that the timing advanced data was subject to a 7-day retention period. Now, and accordingly, the January 5th data was in jeopardy of being purged in a matter of hours. Knowing that he had limited time before this retention period would expire for records associated with January 5th, the public sector employee acted as quickly as he could and attempted to preserve the timing advanced data for January 5th and 6th in response to the January 11th preservation request. And I'm like, why? Why would you be putting in a preservation request on the 11th when this happened, January 6th? I mean, just put the preservation in. The server the employee used for processing the preservation request for the timing advanced data crashed due to the query producing large amounts of data. Okay. Let's make it yellow. This is what he referred to as corrupted data in his January 20th email. The employee could not preserve the January 5th timing advanced data before it was purged. In the January 20th email, the public sector employee therefore notified the FBI that, in his words, the data for January 5th was corrupted and cannot be restored. To be clear, our public sector team never provided the FBI corrupted data concerning the January 5th pipe bomb incident. Importantly, and it bears repeating, AT&T did not produce corrupt data to the FBI in response to any legal demand from the FBI that we may have received related to the January 5th pipe bomb incident. And as noted, such demands may be subject to a non-disclosure order. Okay. Now, happy to discuss this further via phone or Teams best, blah, blah. Now, Assistant Vice President, Senior Legal Counsel, AT&T Public Sector, and First Net. Boop, boop, boop. And then this was back, in 2021. From this person, sent this to this. As you can see how this is all, the data for January 5th was corrupted and cannot be restored. All we have is the 6th. Blank Program Manager, CISSP, AT&T Public Safety Division. Okay. First Net. Okay, I want you to remember this. First Net. Now, Wednesday, January 20th, 10:30 a.m. Hi, guys. Blank and I are in the WFO command post now for Blank. Took over for a few of the agents who left the other day. We were just hoping to check and see if there were any updates, re the Blank info. If it's easier to call to discuss, my cell is below. Special Agent FBI Chicago. There you go. Redact. Okay. Then the What's going on here? Hold on. I have another one. Okay. We're going to go over here to Hector. I printed it just in case this would act up. So here we go. All right, so we have Tuesday, January 26th. Attached are the request records. Call me tomorrow if you need any assistance understanding the data. So that's the 26th. They're just going back and forth. And then the 26th. Okay. Blank from blank. I have been assigned as the SSA overseeing the FBI pipe bomb case at WFO. The blank people told me the blank data for the geofence order was corrupt and lost for 1/5/2021. Is this lost data for just the geofence request? Is blank available for the individual phones of interest during the same period of time and locations? Is it all blank data for 1/5/2021? I am just trying to figure out if we have options as we develop targets of interest. Blank would be extremely help if we had some specific times and general locations for a possible suspect. Any clarification would be helpful. As always, thanks for everything. And so that's this email. Now they attach this right here. Alice from Pittsburgh. Okay. Now we're going to zoom in. Check this out. Loady. Okay. U.S. Department of Justice, Federal Bureau of Investigation. AT&T Wireless Global Legal Demand Center. I missed you. Me too, Alice, baby. You guys, wait, what's going on here? What is this? Does that say Global Legal Demand Center? Well, what is this about? This is the request. Check this out. So it says Global Legal Demand Center, U.S. Highway 1, North Palm Beach, Florida. Attention blank, email blank. Request for preservation of records. AT&T Wireless. Dear AT&T Wireless, pursuant to Title 18 under United States Code Section 2703F, this letter is a formal request for the preservation of all records and information with certain cellular towers, cell towers, that is in the possession, custody, and control of AT&T Wireless at the following two locations. Now, we're going to show you something that's mind-blowing. Remember they said that he put in a request, a preservation request on the 11th? January 8th, 2021. Looky, liars. So Washington Field Office, January 8th, right? So it wasn't the 11th, right? And this is I thought that Global Legal Demand didn't do timing advance. Oh. Say what? Let's see what else. So that is saying we want January 5th from 7:30 to 8 and 8 to 8:30 on January 5th. I request that you do not disclose the existence of this request to the subscriber or any other person, other than as necessary to comply with this request. If compliance with this request might result in a permanent or temporary termination of service to the account or accounts, or otherwise alert any user of the account or accounts as to your actions to preserve the information described below, please contact me as soon as possible and before taking action. I request that you preserve for a period of 90 days. Okay. This, ladies and gentlemen, is this is best practice. Okay. So back when there was a yeah, send me an email, hon. I'll help you. Yeah, just shoot me an email. You got my email? The Mind Challenge. It is normal protocol. The FBI would have done this. Is immediately they definitely within those 7 days. Also because Jack Showalter was driving over there to, Floyd's, what have you. You put in a preservation. You would have preserved all that shit in Pullman on WSU's campus. Meaning, you would have said we want to preserve for 90 days. Okay. These coordinates. Okay. And the times. And so remember Cyrate was saying if you did it for 3,800 subscribers, okay, best practice. I can't imagine that you didn't preserve kind of do all the same things for all the stuff that would be in Pullman. It's really just not believable. Anyways, continue on reading. I request that you preserve for a period of 90 days the information described below, currently in your possession in a form that includes the complete record. This request applies only retrospectively. It does not in any way obligate you to capture and preserve new information that arises after the date of this request. Furthermore, this request does not obligate you to produce any information at this time. This request applies to the following items, whether in electronic or other form, including information stored on backup media. Backup media. All records and other information relating to the account or accounts and any associated accounts, including the following. All that stuff that would have been filled in, whatever you would have known. Any location related data that would provide additional information in reference to the iMessage connected to the tower during the time period requested. This would include any estimated latitude and longitude of the device. Any estimates in the relation to the device's distance. So if you did this, which I am saying that they did, they would be idiots if they wouldn't have done this, if they believed, and they did, okay? There was definitely, you got Pullman right there. The person seemed like they had went, and so you're going to go and preserve just what this is saying here. If this is just for AT&T, right? Everybody knew how to do this back. This was being done in 2021 in January. Okay. And now you get to this case in November of 2022, and nobody knows how to do anything. Nobody knows how to preserve anything in the FBI. Nobody's doing best practice. No, you guys, they did all of this shit. They have it all. Okay. They had it. And what they did is when they got that phone number from what they want to say is, if you want to say we got it off of, from Othram because they did IGG, and then that's how we got his name. And then we looked and tisk, tisk, tisk. Do you think FBI really had jurisdiction? What are you talking about? Jurisdiction? No. They asked the FBI to come in and help them. They used their resources. So the FBI went and preserved all of this shit. And then they used it. They used it. But when they saw that, oh shit, we have a problem, the handoffs, and he doesn't shut his phone off at this time, but if we didn't have these records, then we wouldn't know this. We didn't use this, right? This is all lies. God, you know what else is the biggest lie? I thought that global legal demand didn't do shit. According to Ashley Jennings, global legal demand did not start supplying anybody with timing advance until 2023. Well, this is actual proof that that's a fucking lie. And so I mean, I don't know how many cases I got to go out there and get. This one literally just released all this new stuff because I want to read you this article. How this even came up. Sent. Okay. Today, October 1st. The evidence obtained by Congress in its quest to unravel the mysteries of January 6th. Now, I don't care about January 6th. That's not what this is about. This, for me, is about the AT&T timing advance records, okay? So, but in order to understand what we're even talking about, I'm reading you the article. So, in its quest to unravel the mysteries of January 6th has led the panel leading the investigation to consider that the pipe bombs planted at both the Republican and Democratic National Committees may have actually been part of an undisclosed training exercise. Additionally, new documents raise questions about how valuable cellular phone location data from the days leading up to January 6th, key data that investigators needed for their work, was purged from an AT&T and government system despite a preservation order from the FBI. So what they're saying is that there was a preservation order put in, okay? But yet somehow we didn't get there and we didn't get it in time. Okay. Chairman Loudermilk says that the evidence from the FBI's pipe bomb analysis, AT&T's response to the data request, and a stunning coincidence are leading his panel to consider alternative theories about one of the enduring mysteries of that day. Just the News reported on Monday that the pipe bomb analysis conducted by an FBI laboratory found the devices were filled with chemical building blocks of black powder. Each was equipped with a 60-minute kitchen timer, and each had destructive potential. However, neither device exploded, and they were discovered about 16 hours after the FBI claimed they were planted outside both major party headquarters. To Loudermilk, these details do not add up. In quotes, "I'm not buying the story anymore that they were just there on the 5th. Loudermilk told the Just the News No Noise TV show on Monday. "I believe that they were put out on the 6th at this point. This is the theory that we're going on, especially since the lady that found them said that they were still 20 minutes left on the timer when they were placed there. The other thing is, was there enough explosives in the devices to actually cause a massive explosion? That's one of the things we're looking into at this with these reports, which kind of leads us to believe maybe there wasn't, but they were definitely explosives. Witness statements don't fit FBI's account. Ready? The documents included statements from Carlin Younger, the witness who discovered the pipe bomb, and told the FBI she was certain the bomb appeared in the alleyway near her apartment during a 40-minute period just after 12 noon on the 6th. This conflicts with the FBI's account, which estimates that the pipe bombs were both planted at about 6 about 8:16 p.m. on the previous night, which would be January 5th. Loudermilk said that the current fact pattern and contradictions between the witness statements and the FBI's timeline all lead congressional investigators to consider alternative theories about the purpose of those pipe bombs. One of those theories is that the pipe bomb was part of law enforcement training exercise on the same day as the Capitol riot. Now, follow me on this, he says, this series of logic here. When would you build a bomb that's not designed to go off, but every element of it is to make you think it will, or make a bomb sniffing dog think that it's a live bomb? Loudermilk asked. That's a training exercise. So that also opens the door to that. Was this possibly part of a training exercise? Were they put there just to be a diversion to draw resources away from the Capitol? Since the pipe bombs were first discovered on January 6th, another part of the mystery has remained unanswered. Who put them there? The identity of the individual who planted the bombs would go a long way towards solving the motive or reasoning behind the act. Now, preservation request not followed, cell phone data corrupted. Here we go. However, new documents show how key cell phone location data was deleted from an AT&T and government system just days after January 6th, eliminating a key piece of evidence for investigators to determine the identity of the individual who placed the devices. On January 11th, 2021, the FBI sent a preservation request to the AT&T public sector team to retain precision location data, which provides the distance between the mobile devices and the cell tower it is interacting with, for January 5th and 6th. Now, going back to this. Again, these people are all under the assumption, and I have no idea why, that they did this on the 11th. Please, Washington field office, January 8th. Nobody's talking about this. This is not. Okay, and then here it is. See? January 5th. January 5th. 7:30 to 8 and 8 to 8:30. Okay. Now, again, on January 11th, 2021, the FBI sent a preservation request to the AT&T public sector team to retain precision location data, which provides the distance between the mobile devices and the cell tower it is interacting with, for January 5th and 6th. The data would be vital for the Bureau's search for suspects in the vicinity of the RNC and the DNC that day, when the Bureau said the bombs were planted. However, AT&T told the FBI that data for January 5th was corrupted and cannot be restored. All we have is the 6th, giving rise to the claim from then head of the Washington field office, Steve DiNardo, that the relevant data had been corrupted. Earlier this year, the company told the FBI that the data was deleted from its systems due to a 7-day retention policy. In quotes. You don't understand. A 7-day retention policy. Yeah, that if we didn't preserve it, if you get to it and you preserve it, it wouldn't be deleted. Quote unquote, knowing that this data would likely be purged at midnight Eastern Standard Time, the public sector employee attempted to preserve more precision location data, which was available to them. End quote. The company's senior legal counsel wrote in a message to the FBI in March, quote unquote, at that time, remember this is 2021, at that time, our public sector employee understood that the TA data was subject to a 7-day retention period. Listen to these words again. At that time. That means at that time. That ain't the fucking way it is anymore, motherfuckers. At that time, our public sector employee understood that the TA data was subject to a 7-day retention period. And accordingly, the January 5th data was in jeopardy of being purged in a matter of hours. End quote. The council explained. TA, by the way, is short for Timing Advanced Data, which is what AT&T calls its location dataset per the document. Okay. In quotes, knowing that he had limited time before this retention period would expire for records associated with January 5th, the public sector employee acted as quickly as he could and attempted to preserve the TA data for January 5th and 6th in response to the January 11th preservation request. Again, I don't know what to tell people right here, but if you can just please look and see, this is that document. Okay. Washington Field Office, January 8th, 2021. Okay. This did not go out on the 11th. Okay. This went out on the 8th. And then this is everything that this is the preservation. This came straight from the fucking AT&T and FBI. This was finally released via Kash Patel. Probably to get us off the Epstein shit, right? I'm over here just loving it. I'm like, hello. Okay. So, however, the server the employee used was overloaded due to the large quantity of data, the company told the Bureau. You can read the document below, and that's what I did. I just printed this whole thing out so that I could personally see this. Okay. The FBI's inability to complete a cellular geofence to identify the pipe bomb suspect remains an open question. However, with the newly released documents from the FBI, what we now know raises even more questions. Yeah, it does, bitches. AT&T FirstNet secured a $92 million contract with the FBI about a month before the events of January 6th. When asked by the FBI to turn over cell data relating to the pipe bomb case, all major cell provider companies were able to fulfill that request except for one, AT&T FirstNet. According to FirstNet, that data was inadvertently corrupted and deleted from their server when trying to download. The American people deserve some answers here. Now, so basically two different companies, FBI, first, they're all saying different things. Why do I keep seeing that right before stuff happens, these big contracts get paid, you know? So here's something that's also strange. Strange coincidence involving the public-private partnership. Adding further to the mystery is a strange coincidence. The woman who discovered the pipe bomb at the RNC on the afternoon of January 6th was at the time an employee of FirstNet. FirstNet is a public-private partnership between the Commerce Department and AT&T designated by Congress to maintain the nationwide public safety broadband network in use by first responders. This is the part for first responders. In fact, the senior legal counsel for AT&T also serves the same role for FirstNet, which is housed under the Commerce Department. Carlin Younger identified herself to the media as the witness and recounted her experience finding the bomb to the Bloomberg News, which matches closely with her FBI interview. Younger's public LinkedIn page shows that she was working at FirstNet at the time. Carlin could not be reached for comment by Just the News. I'm not pointing any fingers here. I'm just saying these are legitimate questions we need to be asking. What is the relationship here? The person who found the pipe bomb works for the company that corrupted the data. And then they tell the FBI the data wasn't corrupted. Then they tell the FBI that the data was corrupted. So this is a mess that we've got to unravel. And I will say that the biggest mess, and nobody wants to talk about it, if you guys fucking just read a paper, is why aren't we talking about the fact that the Washington Field Office preservation order was put in on January 8th, not January 11th? How about that, bitches? How about this? Not even caught and noticed. How about that? And then, remember I told you guys back, maybe it was like a week ago, I said, what's the one thing that's missing from any of these reports? Like, go read the 314 pages or the 314 reports from Moscow, Idaho. Go read the 300 or the however many reports from the Idaho State Police. Okay. None of them were doing preservation requests. Okay. But guess who would have been? Guess who's notorious for those? The FBI. I mean, Moscow Police Department, local law enforcement should be doing it too, and so should state police. But you guys, they would have preserved, just like they did the Moscow, like 3 to 5. They would have preserved that same time, if not even potentially, they would have gotten, bigger, like a bigger margin. Pullman, Washington. Pullman. And that's what Cyree was saying, is that there is no fucking way that you did all of these things and then you just didn't do it for this guy, for this area. Fuck even that guy, just that area. I mean, how dumb could you possibly be? If you were doing that same job, it's like, you know that area because you're from that part of. Hey, we got a lot of people going back from Pullman to Moscow. Hey, yeah, we've looked everywhere, and the White Elantra is not on any of the main roads to go this way, or to go, so we think it cut down here, and this is just a straight on shot to get back on over to where? To Pullman. So then you would go and you would preserve that area, and the same thing. Why do you think that they had all the camera footage? How are they getting camera footage after 30 fucking days? How? Because they were preserving shit, because they went and got that shit. This all reeks. And this, though, this proves that looks like you can write global legal demand to get that timing advance, can't you? So what do you think about that, Ashley Jennings? Is this just chap your ass right here, that you could write global legal demand in 2021 and they can get you timing advance records for the FBI? What the fuck, daddy? How about that? This just tells me, and should tell everybody, that, wow. I mean, lies. It's all fucking lies, man. So that's all. Hopefully you guys enjoyed it. Let me know what you guys think in the comment section, but these are all I'm not going to be lied to. So, hey, But he's a conspiracy theorist. Yeah. Cyree's still going to be talking out, just so we're clear about that. Anybody saying otherwise, well, I guess egg on your face later. I think you need to call Ashley and have a chat. Actually, you might be right. You know what? I think I need to email her and then ask her for a comment. That's what we need. We need to send this as an email, okay? And we want a comment. That's what we need. That's exactly what we need. Okay, we're going to fire this over in email, and we're going to say, Ashley, we have some questions, and are you up for the challenge? I don't want Bill. I want just Ashley. Ashley, you're the one that was filling out all of those, responses back and forth. I'm sure you probably took it personal when Cyree basically said you should never fucking have a license again. Okay? I want to give you the benefit of the doubt. Okay? I don't think that you're that bright. Okay? And I think that you relied heavily on a bunch of these bigger wigs around you. And so therefore, I'll give you full immunity on my channel if you tell the truth. My channel is offering free immunity, not to talk about your camel toe, if you just tell the truth about, well, does this, I mean, maybe I'm misinterpreting this, but in 2021, it looks like the Federal Bureau of Investigation could go through global legal demand to actually get timing advance. Okay. And it also basically says that back then it was the 7 days. I don't think that's the case anymore. So I'm just wondering, how do we just get some clarification? Do you have any suggestions, Ash? All right, guys. See you on the flip side. Oh, I'm emailing her and then I'm going to call. They're going to answer. They have to answer this question. I just want Ashley to throw the FBI under the bus. I want Ashley to say, God damn it, it wasn't fucking me, man. All right, guys. Until next time. Peace. Hi, Miss Jennings. This is Lana with Truth and Transparency, and Tina with What the Fuck Translation Services. We got a couple questions for you. When's a good time to chat?